I just want to make it abundantly clear that at no time whatsoever have my convictions, fake Sheik related conviction, ever been safe. They have always been unsafe. I make that clear right at the start because thanks to my functional neurological disorder, brain fog, fibromyalgia and other issues, cognitive issues, I actually say that they were safe at one point in the video that follows. At no point were they ever safe. They are unsafe, always have been, always will be, just to make that clear before this video begins on the 3rd of February 2026. Hey, it's Tuesday the 3rd of February 2026. I'm Alex William Smith by birth, better known as Jonathan Royle, mind magician and celebrity hypnotist, magicalguru.com and also of course unsafeconvictions.wordpress.com. Today, this morning in fact at 10:30 a.m. I went to the Criminal Cases Review Commission in Birmingham and, well, take a look at what I said before I went in to deliver my evidence to them. Oh, and by the way, watch till the end, because then I'll tell you about what happened when I went inside. That will blow your mind. It's the 3rd of February, it's 2026, it's a historic day even, I must get a new set of teeth, but I'm about to deliver tons of fresh evidence obtained from Alex Smith versus Newsgroup newspapers to the Criminal Cases Review Commission in Birmingham. To prove beyond any reasonable doubt that my fake Sheikh Mazher Mahmood related News of the World convictions, which were served to me on the 1st of March 1999, are indeed, as they always have been, unsafe. It's just now that I've got the evidence, the covert videos, the audios, the documents, the photographs, the receipts of private investigators and the people used to ensnare, entrap, manipulate and frame me with fabricated lies. All of this is going to the Criminal Cases Review Commission. Part of my settlement in the case I filed against Newsgroup newspapers on the 30th of September 2022, which they settled using a Part 36 offer weaponised to effectively keep my evidence out of court. You can learn more about that at unsafeconvictions.wordpress.com. They also issued me a private letter of apology in early 2025, apologising for the actions of their News of the World journalists in the formulation of the 1998 story that led to my unsafe 1999 convictions. Well, this little book from Roy Greenslade and Paddy French outlines tons of stuff that the Crown Prosecution Service and the police never disclosed to me or indeed any other Mazher Mahmood victim. It's perjurous lies. Well over a dozen trials collapsed because of his lies, because of his editing of evidence, because of his fabrication of nonsense stories, framing people with lies, the truth of which can now be revealed thanks to what's been disclosed to me in Alex Smith versus Newsgroup newspapers. Don't worry, we are in Birmingham, and that's why it's noisy with the tram going by. I'm also giving them my book, and we'll let that go by. Both volumes of my book, together with over 3,000 pages of witness statements, exhibits, and stuff from other Mahmood victims, with evidence galore that it was always his modus operandi, or modus operandi, however you're supposed to say it, to entrap, manipulate, frame people with perjurous lies, and it was all parts of the supply chain. Heck, in my case, relating to alleged counterfeit coins, I say alleged because the Royal Mint have confirmed that they were never sent any coins to forensically test. There was never any proof whether the coins were real or fake, and in any event, the fake Sheikh kept hold of them for 17 days in total for some of them, 10 days for others of them, before ever giving them to the police. He had no legal right to do that under the Forgery and Counterfeiting Act 1981. He actually broke the law and should have been charged himself with a crime because he committed one, as explained on unsafeconvictions.wordpress.com. So these books are going, evidence galore, statements. The bottom line is, number one, my convictions have always been safe. Number two, Mazher Mahmood's fake Sheikh should have been shut down back in 1994, because there are documents amongst the evidence I'm about to deliver that prove that the Crown Prosecution Service and the police both communicated with each other in 1994 and said that Mazher Mahmood could not and should not ever again be relied upon as a witness of truth. But for some strange reason, they turned a blind eye for another 2 decades until the collapse of the Tulisa Stavlos trial in 2014, at which point they issued some of us Mahmood victims a little disclosure pack with a tiny bit of information about the collapsed Tulisa case. But you know what? They did not issue us no disclosure whatsoever about the over a dozen cases that Paddy French and Roy Greenslade mentioned in their book Royle. Absolutely no disclosure on them. They failed under SEPA rules of 1996. They did not tell us about the collapse cases. They did not tell us that they knew Mahmood was an unreliable, dishonest witness. And they most definitely didn't tell us that in writing they communicated with each other, the police and the Crown Prosecution Service in 1994. And those documents are part of what I'm giving to the Criminal Cases Review Commission today. They communicated with each other, categorically stating that because of a collapsed trial in 1994, based on a story Mahmood did in 1992, that he could not and should not ever be relied upon as a witness of truth ever again. That was never disclosed to me when the fabricated story appeared in 1998. It was never disclosed to me at any point up to my trial, where on the first day, and on the first day of trial only, is when I changed my plea from not guilty to guilty, because I got told that an entrapment defence wouldn't work. Just let this tram past again. Or maybe not. I was told an entrapment defence would not work. I was given bad advice at the time. But more than anything, I now know the police and CPS did not disclose to me that before my conviction that's unsafe, before that, there were at least 5 criminal cases that collapsed because of Mahmood's tainted evidence and perjurous lies, and they knew that and never disclosed it. And in fact, to this day, as recently as a couple of months ago, I gave the Crown Prosecution Service the opportunity to disclose things to me. I gave them the details of what Paddy French and Roy Greenslade have uncovered, that the police and CPS have never disclosed to me. And I said, basically in so many words, do you want to now disclose these things to me? And they categorically, in writing, wrote back and said there would be no further disclosure. Well, there's never been any disclosure except a tiny bit about the police case. The whole thing stinks. One of my previous solicitors, Siobhan Egan of Lewis Naders Law, who represented me in circa 2015 and 16, said on BBC Newsnight that there was corruption surrounding the Mazher Mahmood unsafe conviction. Her words, not mine. But the evidence does seem to suggest that. Another reason why we need Leveson Inquiry Part 2 as well, which was going to deal with police and media corruption. Basically, my phone was hacked. I have evidence that points towards, and this is video evidence that was disclosed to me during my Mittville claim, Alex Smith versus News Group newspaper, video evidence that shows the opportunity of Mahmood's team mixing orange juice from one jug, vodka from another, and the opportunity is there for them to have drugged my drinks. Combined with a witness statement from Steve Grayson, who used to work with Mazher Mahmood, saying he'd witnessed Mahmood drug people's drinks in the course of stings, together with well over a dozen people over the years. It's in the public domain: John Higgins, Lawrence Delagio, Emma Watson, not Emma Watson, that's Harry Potter, Emma Morgan, Herbie Hyde, and a whole bunch of other people have asserted, including Tulisa Stavlos, all asserted they felt their drinks had been drugged. I say the same. My phone was definitely hacked, landline tapped, private investigators used. They were all parts of the supply chain as well, the evidence now shows, because during disclosure, from their files came all the secret videos, all the audios, all the documents, all the receipts for everything they paid out, photographs, evidence galore that shows they were all parts of the supply chain. They manufactured, they made a crime that would never occur, and they also tainted the evidence. They did not give any of the stuff that I've now got to the police and CPS. If they had done at the time, then there would never have been any charges brought, or maybe there would have been, but not against me. maybe they would have been brought against the fake Sheikh Mazher Mahmood, who broke the law in the course of fabricating that story and creating a malicious prosecution. And today, on the 3rd of February 2026, I'm finally delivering the videos, the audios and all the other stuff to prove, as I've always stated since 1998, that things were not as they portrayed them. I always have been innocent, and it was always my intention to try and expose the Mahmood's dishonesty. Go and check out unsafeconvictions.wordpress.com. So that's it, it's delivered. Nobody would come down from the CCRC offices. They'd alerted security that I was going to be here. They were waiting for me, but it has apparently will be passed to them. And we wait and see. Do they cock it up yet again like they did in 2022 when they said I had not submitted any fresh evidence, but I actually had. And as my barristers pointed out, Mr. James Manning of Nexus Chambers, in a cover note for this resubmission to the CCRC, that should have been considered fresh evidence. But in any event, since then, the settlement of Alex Smith versus News Group newspapers has given fresh evidence galore, and you can see that at unsafeconvictions.wordpress.com. Thanks to my functional neurological disorder and other issues, I forgot to thank all of the people who've helped me along the way. Namely, Siobhan Egan of Lewis Nadis Law, who helped me in circa 2015, 2016, 2017 into 2018. And then Mark Lake, the solicitor, along with the secret barrister and the public lawyer, Matt Stanbury, who gave me advice. And that led to me ending up getting in touch with the Advocate Charity, who put me in touch with Mr. James Manning of Nexus Chambers, who's helped me put together my documents and stuff for the Criminal Cases Review Commission and the Court of Appeal. I'd also like to thank Alex Cochrane and Shah Bracken of Edwards Duthie Shamash Solicitors, who helped me with my civil claim, Alex Smith versus News Group newspapers, and the legal team, research team of Dr. Evan Harris, Graham Johnson and Dan Waddle, who helped me get that evidence together to successfully get compensation and a private letter of apology from News Group and disclosure, which gave me all the stuff to be able to go back to the CCRC as mentioned in this video. Everything's at unsafeconvictions.wordpress.com and circusofthemind.net.